For this meeting of the Standing Committee on Agriculture, Environmental Affairs and Development Planning. Today is Tuesday, the 14th of September 2021 at 1 o'clock. And I'm privileged to be the chairperson of this standing committee. My name is Andrikus van der Westhuizen, and I wish to extend a warm welcome to one and all that has joined us on this meeting. Before we start with our agenda, I would appreciate it if the members that are present could just introduce themselves so that we could just establish whether we are indeed quorate. Over to you, members.
Thank you, Chairperson. Good afternoon, everyone. My name is Matlodi Maseko, and I'm a member of the Standing Committee.
Thank you, Honourable Maseko.
Good afternoon.
I just heard Honourable Bartman saying good afternoon. Thank you very much and welcome. Thank you for joining us. I do not see any other members at this point in time. Thank you. I have received some apologies. I believe that Honourable Marais has submitted an apology, and then from people that have been invited to join us, Minister Anton Bredel, the Minister of Local Government, Environmental Affairs and Development Planning, as well as Mr. Piet van Zyl, Head of the Department. They both submitted their apologies. And then I've also been informed that Ms. Karen Shippey will have to join us slightly late due to a clash with other commitments as well. I did hear a voice, and I was just wondering whether it's also another member that may have since joined. No, not yet. Good. Thank you. A special word of welcome then also to our support staff, which includes Ms. Mshumpelo as well as Ms. Niekerk, and our legal advisor, I believe Advocate Marsdorp, has also joined us. Welcome to you. And then a special word of welcome also to our IT staff, Mr. Hassam. Without your support, we would not have been able to meet on this platform. And with that, I would like to hand over to Ms. La Roche, who I believe is going to lead us, but perhaps Ms. Maros, if you would like to welcome some of the people from your department who are also supporting you this afternoon. Over to you.
Good morning, Chairman. Good morning, honourable members and colleagues. I'm Marlene Leross. I'm Director for Biodiversity and Coastal Management in the Department of Environment Affairs and Development Planning. And I am leading the team, the drafting team, which comprises the department, Cape Nature and Legal Services. And Chairperson, if I can hand over to my colleagues then with both within Cape Nature and Legal Services to introduce themselves. Thank you very much.
Thank you.
Good afternoon, Honourable Chair and members. It's Coral Burst, Executive Director for Biodiversity Capabilities at Cape Nature, and I am accompanied by Dion Hignett, our Senior Manager for Biodiversity Conservation. Thank you.
Welcome to you, Ms. Burst and Mr. Hignett.
Good afternoon, Lionel van der Schyff, Legal Services, Department of the Premier.
Welcome to you as well, Mr. van der Schyff. Any other people that have not been introduced to this meeting or to those on this platform? Mr. Njamela, have you been introduced? Good. Thank you very much. So, okay, Mr. Njamela, nice to hear your voice.
Good afternoon, Chairperson. All protocol observed. I'm Loison Njamela from Sarga. I'm an official. Just observing, standing in for Chantel Harogabin. Thanks very much.
Thank you. Thank you. And you're most welcome, Mr. Njamela. Thank you for also joining us. Honourable members, we have on our agenda this afternoon a further discussion on the submissions received in respect of the Western Cape Biodiversity Bill as advertised. And for that, we will be led by Ms. La Roche. And therefore, I hand over to you, Ms. La Roche. If I could just ask the members, if you could stay on. We are just quorate at this point in time. And at our last meeting, we were unable to approve of certain documents, draft minutes and a draft report. And therefore, Ms. La Roche, we will have to terminate the discussion on the bill at about 20 minutes to 4 o'clock, so that we have time just to approve those documents as well. And without further ado, over to you, Ms. La Roche.
Thank you. Thank you, Honourable van der Westhuizen. I'm going to share the comments and responses document, which has been circulated to everybody. Just to remind everybody, at the previous session that was held, we managed only to get to page 38 of the comments and responses table. And with your permission, Chair, I would like us to then start from page 39, noting that this would then conclude the comments we've received from all of the other commentators, except for the DFFE comments, the national comments, which I have appended to the bottom of this table from page 41 onwards for ease of reference. Is that in order, Chair?
Absolutely. Please proceed.
Thank you very much. Picking up then from page 39, and specifically a comment here from City of Cape Town on clause 63. Just a reminder that these are the clauses relating to compliance and enforcement of the bill. The City of Cape Town saying that these powers and functions should also apply to nature conservation rangers, both in their comments on clause 63 and 65. And our note here is just for the record that these powers are reserved for nature conservation officers who are under the supervision of the CEO, in other words, who are employees of Cape Nature, whereas the conservation rangers can be appointed as members who can support enforcement and compliance, but are actually employees of a municipality. And therefore, these powers are effectively provided certainly exclusively for the nature conservation officers who are employees of Cape Nature. So there are differences in terms of the powers and functions of these different cadre of enforcement officials. Our next comment deals with administrative penalties, and you may note that the issues of administrative penalties are one of the areas of innovation in this bill, and effectively SANBI fully supports the incorporation of administrative penalties in the draft bill, and that they provide enforcement officials with viable alternatives to criminal penalties, which are notoriously difficult and burdensome to access. So indeed, this has been part of our approach to modernization and rationalization in terms of the enforcement and compliance and enforcement provisions. I'll move us on then to a comment from the Wildlife Animal Protection Forum of South Africa, which basically voices their support for chapters 10 and 11, which we note. Further then, the request under chapter 10 to remove traps, and unfortunately this is basically pulled into the trap is included within implement, and that is important to just to note, so that it has actually been included. In terms of the Wildlife Protection Association, further comment speaks to the options that should befall a specimen if it is involved in enforcement or compliance operations. And the request here is to look for other alternatives, and they've mentioned a few of these in terms of rehabilitation, rescue rehabilitation facilities, sanctuaries, etc. And what we've included here, that such options are not excluded, even if they're not specifically listed or defined in the bill. These mechanisms can be elaborated in regulations that will also align to IUCN guidelines or best practice. So we believe that those options are included, they're not excluded in terms of the wording of the bill. In terms of Agri Western Cape, this clause speaks specifically to clause, their comment speaks to clause 84 and focuses on consultation. Their suggestion is to include a further sub-clause under 84 and to bring in the following proposed amendments. So as I'm highlighting here, ultimately, this is part already of the legislation, and the underlined part is what they suggest we add. And we concur with that comment and recommend to the committee that we should amend that particular clause to include the following, that to amend 84.1 by adding the requirement to consult with organs of state whose areas of responsibility may be directly affected by proposed regulations or notice. So we take that on board and thank the commentator for that suggestion and recommend so duly also to the committee. Moving forward then to looking at another comment from SANBI, that they're broadly in support of transitional provisions because it resembles that in national legislation and aligns itself with the new legislation that is pending, but also the existing legislation. Then moving on to chapter 12, also looking at the general provisions. A commentator, Wildlife Animal Protection Forum, speaking to the requirement that concerns around transparency and communication and accountability not included in the bill, specifically in terms of PIA and access to information in terms of processes, We note that we can note this comment. However, we are required in terms of our processes to be compliant with both PAJA and obviously to respond to any requests via PIA. But in this regard, also need to uphold the rights of applicants and parties to any administrative process. Moving forward then onto Wildlife Animal Protection Forum, also again on the general provisions under 11 and 12. And again, repeating the requirement or provisions to increase transparency and accountability in transitional and general arrangements. And we believe, again, repeating that appropriate mechanisms are included for administrative justice, and we don't necessarily recommend any further changes. Chairperson, that brings us to the end of the general comments, the comments we've received from everybody else, and then takes us on to the comments provided by the Department of Forestry, Fisheries and the Environment. And we first start with a general covering letter, which was received and addressed to yourselves as the Standing Committee. And here we want to note that they note the process, they appreciate that we're consolidating various laws in the province, that we're modernizing such. Their concerns relate specifically to parts of the bill that potentially duplicate areas of NEMBA, and that they feel that we need to take on board or understand the implications of the high-level panel of experts in terms of the review of policies, legislations and practices on matters of elephant, lion, leopard, rhinoceros management, which relate to breeding, hunting, trade and handling. And indeed, our response here is that the intention of the bill is not to duplicate the effective protection measures for biodiversity already in place. Rather, it is intended to address critical gaps therein. And then also to note that in the repeal of the Nature Conservation Ordinance, the drafters have sought to align and modernize and rationalize the legal administrative requirements. However, protection measures that are not adequately covered within NEMBA have been retained in the bill. And indeed, the bill does propose to address gaps rather than to duplicate. And specifically in relation to the needs of our contextual environment and our local ecosystems. Further then into the issues of the high-level panel, with reference to the findings of the high-level panel, the drafting of the bill has taken a framework approach, as mentioned previously. In other words, trying to strip out a lot of the detail, rather providing for regulations that can readily align to national policy reforms that are envisaged in the medium term. And I must underscore that in the medium term, these policy changes will take probably about 3 years from today. But we are obviously in the position that we need to continue our reforms because our reform processes have been ongoing since 2012, and such future alignment and amendments to the bill may well be required if identified gaps are filled in the legislation, which is finally assented to by the President. But at this point, it's essential that we do fill those gaps in the context of the biodiversity of the Western Cape. Thereafter, the comments that you would have received separately were arranged in 3 different sections within the detailed comments. And what we've done is to group them according to the sequence of arrangements of sections in the bill, so that you can see all the comments together in relation to that particular section. So we've pulled all of them into one space. The first comment from DFFE is around the arrangement of the sections themselves, specifically suggesting that we switch sections around in relation to the areas that involve the CEO and others that involve various other players within the legislation. And what our response here is that the arrangements around any functioning is not required, as the sequence makes sense in terms of the framework legislation. So we would advise not to rearrange the sections, that they make sense as they are, and indeed various versions of the drafts have taken on board such considerations. Moving into the definitions, so there are a number of comments on definitions. The first around authorization, that the term prohibited usually means that the activity cannot take place at all. Should it not rather refer to restricted activity? And just to note, in our definition, the authorization means registration, certificate, license, permit, or other written permission issued or granted in terms of the act that authorizes the person to whom it is issued or granted to do anything that would be otherwise prohibited, and includes an integrated authorization contemplated. So we feel that the definition as it currently stands is fine as it stands. Moving forward then on to definition of biodiversity offset. The suggestion here is that we should narrow it down to only those agreements that are authorized by a competent authority. In other words, biodiversity offset resulting from an approval, an environmental authorization specifically. What we've taken on board here is that a broader definition is preferable to enable broader application and does not exclude agreements that are authorized by the competent authority. So they are not only exclusive, or they're not only inclusive of competent authority decisions, they can be broader than that. So indeed, deal with aspects beyond environmental authorizations per se. Moving forward then onto further definitions, critically endangered species. And this becomes quite a complex set of issues. The specific issue here is considering the implication of the definitions in the following scenarios. One, that species may be listed in different categories, depending on whether it's a global listing or local listing. Two, species may be listed in a particular category in terms of NEMBA due to trade concerns. But a red list assessment has not been done for that particular species yet, or species may be listed in accordance with the IUCN red list criteria. But those species may have been listed by SANBI, but not the IUCN itself. For example, the latest red list assessment for mammals. So our response here is that a critical endangered species means indigenous species as listed by the IUCN as critically endangered species, and includes a species listed by the provincial minister in terms of section 49(2)(b), so that the bill actually indicates the intent to acknowledge the IUCN threat status, which is global, whether it is global or regional, and which are integrated. For species that are not yet assessed, provision will be made through mechanisms provided in the bill. Note that threat status is not only determined by activities that threaten the species, it includes abundance, limitations, etc. For example here, we use an example here of Visagi's golden mole. Note that TOPS only lists species which are threatened by the activities listed in NEMBA, but regulated in TOPS. Unfortunately, the TOPS listing is not always aligned to the IUCN threat status. So in other words, even though Visagi's golden mole is considered as threatened, it would not be covered under TOPS because nobody is really harvesting currently, specifically utilizing that particular species. Moving further on to definitions, definition of development. So the definition here, the comment is item E, that this definition is more of a planning process than actual development, that we should consider replacing process with something else, as the process itself is not what affects biodiversity, but the outcome of the process. We would partly agree with that. However, the intention here is to include the processes that change the use or function of a place, which include by definition planning processes. And indeed, honourable members, the one critical area that the bills really sought to integrate and articulate effectively with planning legislation and the definitions within such planning statutes. Moving forward then to the definition of environmental legislation. And this particular comment dealing with, although NEMA is framework legislation, it also includes substantive content in environmental impact assessments. Perhaps include a reference to it here as well. It is better to refer to any act defined as a specific Environmental Management Act under NEMA, but rather to list them by name. The implication is that when another act is added to the list in terms of NEMA, the provincial definition becomes outdated and will have to be amended. Okay, so we've noted this, but legal reform process will in any case result in changes which we cannot anticipate by reference in advance, but agree that amendment may be required in the future. Moving on to definitions of export, and we agree that this comment and suggested change should be, we recommend to the committee for your consideration as an amendment, that it should mean the transfer or attempted transfer of any species or specimen. And indeed, we suggest that we do amend that definition accordingly. Okay, and then moving further on to the definition of hunt. And unfortunately, that's broken off into 2 pages, but is the question from DFFE that the shooting of an animal with a dart for the purpose of capturing the animal will be regarded as hunting? If so, would a person need a permit to hunt or to capture? And the short answer is yes, because if you read the definition, it says hunt in relation to a wild animal, an animal belonging to a non-indigenous species or a feral animal means to search for, pursue, follow or drive, lie in wait, or willfully disturb or shoot or poison the animal by any means whatsoever for the purpose of killing, injuring or capturing or attempting to kill, injure or capture it. So indeed it does include such activities. Moving forward then onto the definition of landowner. Landowner here specifically pointed out here is the potential gap in the definition, as landowner potentially being a management authority of a protected area. And we checked carefully to make sure that there is no gap. We believe that there is no gap currently. If you look at the definition, includes under A2, anyone who exercised general control over the land, which we believe to include a management authority for a protected area. And I'm jumping over the rest of that because it's simply the wanted to highlight that particular aspect which we believe covers management authorities. Moving further on to definitions, definition of well-being. The definition of well-being as put forward in the NEMLA Laws Amendment Bill specifically speaks to well-being means the holistic circumstances and conditions of an animal which are conducive to its physiological and mental health and quality of life and ability to cope with its environment is the recommended amendment. What our concern is that holistic circumstances are not defined and are rather nebulous, and we need to be very specific when it comes to definitions in law, ultimately in their application specifically. And also we're concerned to introduce more terms which themselves would be difficult to measure or define. We do, however, taking on board this comment, suggest that we potentially look at amending the definition by replacing the existing definition with the following. Well-being, as it relates to animals, means the state of ecological, behavioral, physical, and physiological health of an animal. We're recommending to the committee, therefore, that that definition goes part way in carrying forward this particular comment from DFFE. In relation to clause 6, principles of ecological sustainability, and a comment we have received, I think, 2 times before this, that they suggest that we bring in the Section 2 of NEMA principles in terms of a cross-reference, and we also agree that this is appropriate and suggest that we amend clause 5 actually rather than clause 6, which refers to the application of these principles, to speak to the following: to amend clause 5 to include and apply the environmental management principles in section 2 of the National Environmental Management Act. Moving further on to the clause 10, duties of Cape Nature and comments thereon. If the functions of Cape Nature are set out in this section, there's no function relating to the implementation of the provision of this Act or its subordinate legislation. Speaks to also then more detailed comments on World Heritage Sites, that pointing out that that's a national competency, as well as looking at enforcement of detection of non-compliances and enforcement being added specifically. In response to this set of comments, we note that Cape Nature's function and powers are set out, but there are other parties also identified with functions and powers, including Provincial Minister, CEO, the board, and the HOD. So that is why the powers and functions are specifically set out in the manner they are, specifying those particular powers and functions to specific parties identified. In relation to clause 10 and World Heritage Sites, absolutely, this is a national competency. However, Cape Nature is appointed as a management authority in terms of World Heritage Sites in the Western Cape. Moving on then to the comment on clause 10.1p, just to note, inspect and investigate non-compliance and offences in terms of this Act. Note the section on compliance and enforcement, and O, in areas under its control, take measures that are necessary or desirable for the conservation of biodiversity or the management of adverse effects thereon. So just to note that one should look further down this list of functions and duties and see that it is indeed included, the requirement to take measures necessary or desirable. On clause 11, powers of Cape Nature, if Cape Nature undertakes restricted activities themselves, they may well trigger permits in terms of national legislation, i.e. in terms of Biodiversity or Protected Areas Acts. This may require permits, authorizations from national department. We agree, and that this is not excluded from 11.4. Any such requirements would prevail anyway. In terms of clause 37, use and application of the biodiversity spatial plan. The question here or the issue here is that no provision is made that a plan approved in terms of this Act must be consistent with a plan developed by a minister, national minister in terms of NEMBA. And they suggest a new provision to be contained, or they refer to a new provision to be contained in NEMBA involving a future piece of legislation and they set this out. Our response is that we note that the BSP may be more restrictive than a national biodiversity plan contemplated in amendments to NEMBA, but the issue is that that does not yet exist, that particular legislation nor plan. And then also to note that this BSP is an addition to NEMBA, noting that provincial conservation planning may be more current and at a greater level of detail. So there's no intention to be in conflict with any national plan. Certainly it is to elaborate where necessary the detail contextual requirements of our own ecosystems. Moving forward then to clauses 34 to 36. And it's a little bit of repetition, but I'll take the committee through the systematic biodiversity plans. Is largely commentary here. Makes provision for the biodiversity spatial plan. It's ultimately seen as a systematic biodiversity plan. They're noting that NEMBA makes provision for bioregional plans, that the proposed new bill will provide for spatial biodiversity plans for municipality or province, that those are also systematic plans. The major difference is that our bill, the Western Cape bill, is more specific on the consequences of adopting the BSP than both NEMBA and the NEMBA bill proposed. But then ultimately, the request here is to having regard to this to potential duplication of the provisions, but also taking into consideration the Western Cape Province's intention to better ensure that the plan is taken into account in planning and decision making. We propose that the bill is deletes the provisions relating to the preparation of the BSP, but retains the provisions relating to the consequences of adopting a systematic biodiversity plan. And that we remove BSP or biodiversity spatial plan and replace it with bioregional plan. Okay, our comment and response here that the BSP is an addition to what is proposed by NEMBA and is well within the purview of the province's legislative mandate. Noting also that conservation planning may be at a more detailed level and within the province. And also then to note that it is proposed to address a gap in addressing the preparation of a provincial biodiversity spatial plan, retaining one element which does not refer to the proposed regulatory framework in the Western Cape, doesn't make sense in terms of coherence within the bill. So we do not agree with removing provisions relating to the preparation and adoption of the provincial biodiversity spatial plan. Moving on then to further comments, that's clauses 34 to 36 again, and I think this is where the repetition for the different sections of the comments comes in. Bill makes provision for the BSP, deemed to be a provincial plan in terms of the Local Government Systems Act and the Spatial Planning and Land Use Management Act and the Western Cape and Land Use Act. It must be taken into account in a wide array of environmental decisions. There's no explicit requirement for planning instruments such as IDPs to be taken into account when developing the BSP. Municipalities in the province are required to show how land use planning categories and the spatial development frameworks have taken into account the desired management objectives and the guidelines of the BSP, and that NEMBA makes provision for the adoption of bioregional plans for bioregions. In South Africa, bioregion plans are based on provincial systematic biodiversity plan, but slight amendments are typically made to the plans for the purposes of preparing a bioregional plan to address potential land use conflicts, amongst other planning instruments. Chair, I'm not sure if I'm going to read all of this because I think it goes into some commentary, and I believe that the committee would have had a chance to look at this. our response ultimately here, and because actually the comments are repeated in the different sections, is that we propose to maintain and retain the Provincial Biodiversity Spatial Plan requirements, and also just to note that the Provincial Biodiversity Spatial Plan must be taken into account in the development of IDPs and STFs, rather than the other way around. You know, you can't really move and shift nature. You can't move rivers and wetlands. However, one can move where one plans to put industrial development or housing. Just as to note, that is a specific response to what informs what in these spaces. So indeed, the biodiversity spatial plan and layers from biodiversity and natural systems really are a critical informant in SDFs and IDPs. Moving forward in terms of the protected areas expansion strategy, they're noting that, and I'll just summarize what is put forward here, noting that we're putting forward the requirement for the protected areas expansion strategy for the province to be adopted. They support this clause, and they're bringing it into your attention that it's the department's intention to also insert such a provision in NEMPA in the future, requiring the minister, national minister, to adopt a national protected areas expansion strategy, and for each MEC also to adopt the same for the province. But they also note that it is unlikely that NEMPA amendment will be finalized in the near future, but that we may want to review clause 39 in the future if indeed NEMPA is amended to reflect such. And we note such. They also note it will be a while before any amendments are made. So we believe that in the interim, it's very important to move forward with the coherence that is suggested under clause 39. Moving further on 39, it's really a repeat of the same comment, and which we note. Moving on to clause 40, declaration of mountain catchment areas. And this comment here is one which we would like to take on board. And specifically, it is the requirement which, before pursuing a notice contemplated under subsection 1, the provincial minister must, in the prescribed manner, notify the landowners concerned of the intended notice and the consequences thereof, and afford them reasonable opportunity to comment. And therefore, we believe to align to other sections of the bill that we would like to provide that addition in 40 subclause 5 as set out in the comments and responses table, to add the further subclause and afford them reasonable opportunity to comment. Moving further into other comments on mountain catchment areas, again, it's preceded with some commentary. They do have some comments. They say on clause 40, the general observation here is that in terms of NEMPA, mountain catchment areas are deemed to be protected areas. And the issue here, which we agree with, is that mountain catchment areas are only recognized as protected area if they were declared prior to NEMPA coming into effect. Therefore, any new areas declared under the bill would not be recognized under Section 12 of NEMPA. And we agree with that comment. But in terms of consequence, we don't believe that there is an amendment required. The other issues raised in relation to mountain catchment areas, they say it is possible that mountain catchment areas could be deemed to be protected environments or nature reserves in terms of Section 12. That would have implications for how mountain catchment areas are managed. It would not have the protection in respect of mining. In terms of 48 of NEMPA, we agree with that. A second observation is that the bill already contains the clause 47, allowing for the protection of ecosystems and ecological infrastructure. And they're wondering whether this would be superfluous, seeing that those other clauses exist. And then a third observation, it's not clear whether that list is supposed to be conjunctive or cumulative, and whether there should be an and or an or there. I will now respond to those issues individually. In relation to mountain catchment areas, we've responded to the issue that any new areas would not be recognized under 12 of NEM-PAR. And then also to note, as background context for the committee, that the purpose of this section of the bill is really to ensure that the status of mountain catchment areas is not lost. One cannot just summarily deem these MCAs, mountain catchment areas, to be deemed to be other sorts of protected areas, for example, protected environment or nature reserves. There would be an administrative process required in order to change their status into those particular types of protected areas. And hence, these specific inclusions in the bill are really there to ensure that while alternative mechanisms for securing strategic water source areas are concluded by national government, and or portions of these mountain catchment areas are regularized into such formal protected areas such as nature reserves or protected environments as relevant and as desirable. So to note that we're broadly in agreement, however, we cannot summarily or simply deem these areas to be either nature reserves or protected environments. There is an administrative process that is required to transform or to regularize them into those spaces, and also to keep our eye on the legal mechanisms for securing strategic water source areas, which will have significant coincidence with mountain catchment areas moving forward. In terms of the observation around whether the list under subclause 2 is conjunctive or cumulative, we want to note that this provision is neither conjunctive nor cumulative. Rather, it allows for one, two, or all of these requirements to be met. Moving forward also then on mountain catchment areas, and I think there may be a little bit of duplication here in terms of this comment as well, coming from the 3 different sections of the DFFE comments. Not going to read through all of it, but ultimately it is a repetition of the comment we've just covered. And also to note that the future proposed revised or the NEMBA bill, which is also being processed in the background, which hasn't yet come to us, come to this committee formally. It's still I think it's still being approved by National Cabinet to go out for its public participation. That we note that similar roles in terms of protection of ecosystems are provided for. Okay, then in terms of clause 47, and this specifically deals with the protection of ecosystems and ecological infrastructure. Again, this is a commentary that speaks to various observations, which I'm not going to read through in detail for the sake of time. The nub of this matter really is set out in the comment 9, which I will highlight here, is that really their observation ultimately is that given the bill has more flexible provisions for the conservation of ecosystems and ecological infrastructure, we do not propose that the bill's provisions relating to these matters are deleted. However, if and when the NEMP bill comes into force, these provisions could be reviewed, and we note that and accept that. Again, this is duplication in terms of commentary on terms of lists of ecosystems. Moving in again to the final paragraph, which really speaks to currently the proposals in their draft legislation, similar to the bill, that the minister is given much wider discretion on how steps could be taken to better manage ecosystems that are endangered or in the need of protection. And the NEM bill however, does not authorize the MEC to adopt a list of ecosystems that are threatened or in need of protection. And this is where ultimately we would say that it is indeed desirable to enable the MEC to provide for such listing. However, to note that such listing would be done in concurrence with the national minister. Moving on to clause 48 and specifically the issues related to biodiversity offsets. A commentary here is the process currently underway in developing guidelines, national guidelines for biodiversity offsets, which we are directly engaged with and assisting with, working very closely with the drafters of that guideline. Specifically here, we understand the rationale for clause 48 is to supplement the national system to ensure that provincial conservation priorities can be pursued. However, clause 48 does create the possibility of inconsistency between these different instruments with principally the same objectives. We recommend that we continue to work collaboratively with DFFE, and when environmental management instruments are being prepared in terms of NEMBA or this bill, to avoid any inconsistency between national provincial management instruments. We note and we agree an alignment is absolutely necessary and desirable and is currently being worked on. In terms of 48, I believe this is again a repeat that we would absolutely need to work within the overarching national principles, that we note this, we agree to this, and agree that alignment is necessary and desirable. Moving on to clause 49. Species in need of protection or posing a threat to the environment, and specifically asking what is the possibility of being able to obtain an integrated permit. Indeed, integrated permits are provided for in clause 54, and in this instance there's no overlap with TOPS. It's not proposed or provided for any overlap there. In terms of 49, moving forward then, again, commentary in terms of what the bill proposes in clause 49, and a comparison to both the bill that is currently being drafted and NEMBA in its current existence. The comment here basically is set out, or the actual comment is set out in 6, which is recommended that that clause 49 of the bill is amended to exclude the conservation of critically endangered, vulnerable and protected species. And here we have very specific response, which we would like to share with the committee. It's important to note that the discretionary clause allows for the minister to list species not adequately protected under TOPS. The purpose is to align with the policies emanating from the high-level panel report and the proposed draft and the current draft paper, and hence the bill is written as framework legislation. In other words, writing in that ability, the agility to align with this emerging policy. Also note that the above section, or the section on integrated permits, would enable a rationalized approach to authorization in the scenario where a species is listed in both national and provincial legislation. Note that the purpose is to address the gaps in the current TOPS listings, which includes only species which are impacted by the listed activities. The process of up or down listing is intended to be more dynamic and responsive. For example, in recent cases, and this is just for noting and for information, in the recent cases, about 90% of the species of succulents which were subject of succulent poaching recently, you may have read about this in the news, no enforcement would have been possible under TOPS because they're not listed there. And hence the provisions under the Nature Conservation Ordinance were absolutely instrumental in being able to bring these transgressors to book. Otherwise, there would have been no effective enforcement or penalties relevant. And hence, it's important for this subsidiary listing, this provincial listing, to be made to be available, and for the MEC to have these discretionary powers. Further under 49, again, this is effectively a repeat of some commentary in relation to the comment that we've just moved through, but it brings in the element of invasive species as well, which we will deal with just in the next comment. It's seen as desirable for province to publish a list to address gaps in the TOPS listing as explained above. Won't repeat that. And then also noting that there is the provision for integrated permits if needed. And again, just to underscore that the provision is discretionary to address gaps rather than to create duplication. Then specifically under clause 49, we include the ability to list alien, extralimital, and invasive species. And again, this comment is quite detailed. It's some commentary to start with, and then specifically goes to suggest that since alien invasive species are comprehensively dealt with in NEMBA and the proposed new legislation, in that they believe that clause 49, insofar as it deals with alien extralimital species, is unnecessary. It is therefore recommended that clause 49 of the bill is amended to exclude alien and extralimital species from its scope. We note the comments. The MEC does not require national legislation to empower him or her to list such. These are existing provincial legislative competencies. However, we've noted that clause is discretionary and will enable gaps in legislation and listings to be filled. The intention will not be to create duplication or any conflict. Moving forward into clause 51. And this particular matter, I believe, is an improvement in the drafting. We're grateful for. Specifically, the consideration of the compliance profile of the applicant. If there's evidence that a person may be a repeat offender, should they not be considered a fit and proper person to hold such authorization? And then also the need to include a ground for refusal if the application is inconsistent with any restricted activity that's prohibited in terms of national legislation and specifically the NEMBA. And we agree that such consideration should be taken into account, i.e., as contemplated in 51.2, it would be undesirable to automatically refuse authorization based on prior convictions or to make such considerations a matter of law. Where such prohibitions exist in terms of court orders findings, such would need to be applied. So we wouldn't automatically make that part of the grounds for refusal. However, one would need to take into account any findings or court orders made against such applicant previously. In relation to the second comment, we submit to you to consider the addition to refer to the requirement to be consistent with National Environmental Biodiversity Act. So under this particular sub-clause 51.3, the Chief Executive Officer must refuse an application if it is inconsistent with the principles listed in Section 6 or other provisions of this Act, any relevant strategies, plans adopted or approved in terms of this Act. The inclusion then would be C, Biodiversity Act, or, and then D, as it was before, subject to Section 231 of the Constitution, any applicable international agreement. Moving forward on to Clause 52, risk. Comment which we also recommend we take on board in an amendment, that the CEO does not automatically grant the application of authorization, but makes a decision on that application. And we agree that this wording should be amended to read as follows. 52 should therefore read, before making a decision on an application for authorization, etc. So we thank the department for that. Is certainly an improvement to the drafting of that particular clause. Clause 53, legal proof of legal possession. A question here is, does this section refer to a specimen listed of a listed species contemplated in 49.2, or also to specimens of species that are not listed? And here we refer to the definition of specimen, which means any living or dead animal, plant, or other organism, seed, egg, gamete, or propagule, or part of an animal, plant, or other organism capable of propagation or reproduction, or in any way transferring genetic traits, etc. So our definition of specimen, we believe, is broad enough to include the issues which are both listed or not listed. Moving on to clause 54, integrated authorization. Okay, then the question here is, or the issue here is the statement that the scope of legislation that can be integrated in this manner must be limited and spelled out, as it can't be everything that the CEO is responsible for. Absolutely agree, but this clause does only refer to authorizations and not everything that the CEO is responsible for. So we believe that it's correct as it stands, and it only refers to authorizations currently. In terms of Chapter 9, compliance and enforcement, issues here that these clauses, mandates and duties, very similar to those of EMIs, and with the current provision of NEMLA Bill, there will be two sets of compliance and enforcement officials, NCOs and EMIs, that are mandated to undertake compliance and enforcement with similar but not the same powers. We agree. The NCOs are empowered to enforce the bill, whereas EMIs are empowered under other national statutes. The bill provides for these powers in terms of replacing, modernizing, and aligning similar provisions from the NCO, Nature Conservation Ordinance, which are to be repealed. Moving forward then further into issues under compliance and enforcement. The comment here is effectively pointing to the concern around the similar functions of nature conservation officers and EMIs and their similar roles and responsibilities. And then the question here, or the specific issue noted under 3 and 4, specifically to avoid overlap, which we agree, and also to note that there are minor differences. Specifically, the concern related here is that officials would need to know both laws and make sure to exercise powers in terms of the right set of laws when monitoring compliance. Just to note that nature conservation officers currently operate in the context of EMI designations as well. We currently work in this context, and there's no difficulty in distinguishing roles, powers, and functions currently. Some of the nature conservation officers are also designated as EMIs and have powers under national legislation. So the proposed changes in NEMLAB will allow EMIs to enforce provincial conservation laws. This can work alongside these provisions and is thus not in conflict. The MEC in any case has powers to appoint enforcement officials in terms of provincial legislation. We don't agree that these powers should be removed. Indeed, we believe that these powers are necessary in terms of replacing, modernizing, and aligning similar provisions in the Nature Conservation Ordinance. And also to note that many enforcement officials will also potentially be appointed as fisheries control officers or as peace officers, and currently have to navigate all relevant statutes and powers thereunder. In terms of further comments under compliance and enforcement, I believe that these are also commentaries which are very similar to the comments that we've just worked through. It's pretty much a comment, the comment is a repetition of the above, and response would be as above. The suggestion that we delete the bill's provisions on compliance and enforcement, we disagree. Enforcement will be required for the bill in areas where there are gaps in national legislation, and we therefore don't agree with the deletion of such sections. In terms of having two regulatory regimes dealing with compliance, monitoring, and enforcement, maybe make it more difficult to implement the bill. They'd need to know all the different laws and make sure to exercise the right powers. We agree, as is currently the case under enforcement of the Nature Conservation Ordinance and other relevant legislation I've mentioned above, including marine living resources, regulations, and general powers as peace officers as well. Okay, and then effectively this is the same comment, but just from a different part of the consolidated comments received. Moving forward onto the mandate of nature conservation officers and nature conservation rangers. In terms of the National Laws Amendment Bill before the NCOP, an MEC may designate a person as an EMI for enforcement of those provisions of the Act or any specific Environmental Management Act or any provincial act that substantively deals with environmental management. This means that there will be two parallel sets of officials that can undertake compliance and enforcement of this legislation, EMIs and nature conservation officers, rangers. Is not ultra vires to include this provision? The provision empowering NCOs to undertake compliance and enforcement must come from that other law. It is in any case contemplated in NEMLAB for there to be a national and provincial legislation enforced by EMIs and or nature conservation officers. So ultimately, these would be working with provincial and national legislation in any case. And just to note that the power to enforce under 58B comes from that other law. Section 58 as such is not an empowering provision, to note. Moving on to clause 59, honorary nature conservation officers. This provision needs to be more explicit. Can the honorary NCOs only exercise powers which, when accompanied by an NCO, or are their powers confined to some or all of the NCOs as indicated below? Okay, and then the issue here, the powers of honorary nature conservation officers have limited powers and are only those set out under clause 59.3. Nothing more, nothing less. In terms of clause 61, identity card and letter of designation, just a practical note, listing all the powers of an NCO and on an identity card may not be feasible. We note that. But often these cards are carried with the relevant legislation listed and then letters of appointment, which can deal also with those details if necessary. Clause 63, routine inspections. The word search should be removed from the power committee, honourable members. We agree that this potential for confusion should be removed in terms of blurring the lines between routine inspection and investigation, and hence we support the clarification of this in particular intention. So the search is qualified for the purposes of ascertaining compliance only. However, the intention of the research is thus clarified under clause, and we remove that word search and replace it and recommend its replacement with examine. So in the course of a routine inspection, and to avoid any lack of clarity, that we suggest to yourselves that we amend 63(1) to read: a nature conservation officer, subject to section 58, may at any reasonable time conduct a routine inspection and, without a warrant, enter and inspect any premises or examine the contents of any bag, box, or other item for the purposes of ascertaining compliance, etc. Moving forward then to the other comments under 63(2), to note, also they're suggesting that there's blurring of powers. Also, it has been raised that the Magistrates Court Act only permits a magistrate to issue a search warrant to a police official, and NCOs would not be police officials. We agree that the usual powers of the CPA apply, Criminal Prosecutions Act apply, and it is important for training of relevant officers to be able to assess the situation on the ground. It is not necessary to specify these procedures in the Act. Note that the intention is within the routine inspection and to provide for practicalities and eventualities in such operations. Perhaps the commentator is referring to the Magistrates Court Act in error and means to refer to the Criminal Procedures Act, in which such is detailed, and perhaps the comment is referring to clause 64, which actually deals with warrants. Search warrants are issued under CPA, and the bill is seen to be valid in terms of under section 19 of the CPA. Moving forward then on to administrative enforcement. As stated previously, this creates a parallel power to section 31L of NEMA and compliance notices. There will need to be clear operational guidelines agreed, and the revision of such operational guidelines will very much be important. Moving on to clause 71, current project underway to develop administrative penalties under the NEMA-SEMA framework. We note that. In terms of 73 penalties, and specifically here, the request is to consider alignment to specific fine amounts, which is defined in NEMA, rather than leaving it specifically to other measures and other calculations. We've agreed that and recommend that the direct alignment to NEMA penalties provisions in order to encourage appropriate fine amounts. So the reason why these amounts are specified, and just to note that they're an upper limit, they're not a minimum, that to try and elevate the seriousness of environmental crimes, because the experience is that often fines provided for by magistrates may not be commensurate with the offences, and hence NEMA has chosen to specify certain categories of offences and indeed certain levels of fining or amounts of fining in bands. And as I've mentioned, upper limits are defined, the wording being a fine not exceeding, for example, 10 million or as the case may be. And hence we propose an amendment to clause 73 for your consideration, honourable members, that we align the fine categories and penalties to those of NEMA. Moving to clause 74, and noting we're on second last page as well. How is it appropriate to specify what a court can find? Okay, this is under 74. cancellation of authorization. There is nothing unlawful in providing guidance, especially since the experience on the ground is that on requesting such remedies, magistrates regularly ask for clarity as to where such options are set out in legislation. Note that this is discretionary guidance, may. Moving on to 75, award of costs. Should it be and or? And we say no, it should be both, either A or B. So we will not take this change. We would not recommend any change here. It could be both or either, and hence we don't specify and or. In relation to exemption, 79, this implies the CEO has all powers in relation to sections of this Act. This is not correct. Provincial Minister has powers that they believe should be made clear in terms of exemption. The wording suggests that the CEO can exempt from any provision of the Act, when in fact the CEO only deals with authorizations, should be limited to Chapter 8 authorizations. And our response here is that clause 79 is clear. It only applies to authorizations. And we just include that section here for clarity. 79.1, the Chief Executive Officer may, subject to any conditions as the CEO may specify, exempt any person from the requirement in terms of this Act for authorization or a condition of an authorization. So the foregoing provisions in the bill have provide clearly for the separation of the duties and powers of the minister. And just to note, those are in clauses 7.1 and 2. And then finally, clause 81, what is deemed to be where this is required? Everywhere there is a reference to regulations does not make sense. Okay, so it was a little bit cryptic, this comment. However, we just want to note for clarity that regulations are specified within relevant clauses, which specify whether regulations must be or may be drafted, or whether they are discretionary. So instead of separating them into a separate section and listing them there, they indeed relate to the specific section or clause of the bill where such substance is dealt with. Honourable Chair, I therefore thereby conclude my presentation of the comments and want to request clarity. Would you like me to move into the issues relating to the schedule of repeals in terms of clarity on those aspects?
Thank you, Mr. Ross, and thank you for the detail. And I take my hat off to you for having to speak for so long on this document and dealing with us in such detail. I'm wondering, I'm just going to give you a little bit of a break and an opportunity to take a sip of water. And I'm going to ask Ms. Niekerk. Ms. Niekerk, we also received a submission in which one of the members of the public, I think it's Mr. Steenkamp, requested to appear in person before the committee. He then later indicated that he may have connection problems, and he then submitted a piece which he requested to be read into the proceedings of this meeting. And I'm just wondering, Ms. Niekerk, whether you would be able to bring that up onto our screens, if you could beam that, and whether perhaps you would be so kind to just take us through that submission from this member of the public. Over to you, Ms. Niekerk.
I shall do so, Chairperson. Just give me a moment to then bring up the document, all right?
Good, thank you. I know I've been quite quick on you. Then, honourable members, what Ms. Burgess just referred to, this Western Cape Biodiversity Bill, once adopted, will repeal quite a number of pieces of legislation, which unfortunately we've not been provided with copies of. For me, before we can decide on which pieces of legislation must be repealed, I think it would just be appropriate for us to know what was covered by each of those pieces of legislation and why it is now deemed to be obsolete, or why, what portions of that would now be integrated into this new biodiversity bill. I think we are all in favor of, bringing different pieces of legislation together. It makes it much easier for everybody that needs to deal with and that needs to comply with such legislation. But I didn't feel comfortable to repeal laws without knowing, what are we stepping away from. And that is what Ms. LaRosse just referred to. Ms. Niekerk, I presume it might be difficult to enlarge the font there. Would you be, as this was directed at you, would you be so kind just to read us what Mr. Steenkamp submitted? Thank you.
Okay, no problem, Chairperson. The email reads as follows. I write this email as we are again plagued by electricity blackouts due to cable theft and have no guarantee that I will be able to connect to the committee meeting on Tuesday. Could you therefore please add these comments to my previous record and have it read out at the meeting in lieu of my virtual attendance? If not, please inform me so that I can attend in hope that our electricity supply holds. I have noted the reply to my comments and reread the objectives as set out in the Western Cape Biodiversity Bill. They are noble ideals and should cover most of my concerns, but I need to add that the devil is in the details flowing from these broad objectives and that have to be rooted in reality, a reality that needs to be understood and addressed. Otherwise, it will not aid the conservation cause. I have pointed out some of the realities we encounter in my previous comments and add them further below. Over the past 2 weeks, I have canvassed opinion on conservation from parties in the valley and have been surprised by the extent of us, in brackets landowners, against them, in brackets conservation authorities or bodies or government, sentiments and even expressions of hate for Cape nature. For emotions to run so high clearly shows major problems in what should be a partnership to protect the environment. Our personal objective is to conserve our land, a renosterveld or Karoo succulent or fynbos transition habitat, as a wildlife sanctuary to ensure a pristine natural environment destination for a future ecotourism venture. A venture for which the next steps are being delayed until clarity appears on the proposed expropriation without compensation looming fiasco. I have already described our issues with poaching of endangered succulents. Since my previous comments, a further plus minus 1,500 conophytum clusters have been poached and retrieved where they were dumped next to the road a few kilometers away. I had to construct a special enclosure to house these plants for the next 9 months till the next rain season for transplantation in the natural habitat. This, however, is in addition to stopping illegal hunters with their packs of dogs, removing often up to 15 loop traps a week along wildlife pathways. These further poaching activities mostly take place at night, and it's a difficult and dangerous activity to confront the poachers. Since our conservation actions have started there, has been a remarkable return of wildlife. To create awareness for this plight, we approached Carte Blanche to investigate succulent poaching, and this program has since been broadcast and can be viewed on the following link. As a consequence of the Carte Blanche program, family in New Zealand noticed conophytum plants for sale in their local nurseries and have approached the authorities to investigate the source. If the black market trade is pressured, the demand should decline. What have we learned from our conservation efforts? Number one, government offered us little more than lip service with a constant excuse, the lack of resources. This is an unacceptable excuse and should rather be lack of effective government, real commitment, and political will. To quote William Gumede in today's Sunday Times, if the conservative estimate of 3 trillion rand that was directly lost, without adding the capital, resources, and talent that left or decided not to invest in South Africa because of corruption, mismanagement, and incompetence during the 9 wasted years, was used wisely, conservation, among many other responsibilities of government, would be a much better state. Number 2, police and courts seems to have a poor understanding of plant poaching crimes and mostly do not take such crimes seriously, and it requires effort to have charges laid, investigated, and prosecuted. Without all organs of state working together to meet these conservation objectives, landowners face an uphill battle, and so too biodiversity. Number 3, private conservation initiatives are dangerous and expensive to undertake, and we are generally considered as crazy for doing it, and we certainly represent a very small minority that do more than talk about it. The reality on the ground is not sustainable. Most landowners are so overwhelmed by other realities ranging from crime to economic and political pressures that active conservation is an unaffordable indulgence. Shireen, I thank you in anticipation for forwarding this mail to the committee and wish them much wisdom to find a sustainable path to achieve the set objectives and forge the partnerships required to do so. Best regards, Mr. Louis Steenkamp.
Good, thank you very much.
Person.
Good, no, thank you very much, Ms. Niekerk. There we've got it, honourable members. It's been read into the record, and also obviously our colleagues from the department are free to respond to that, just as they responded to any of the other input received. I would appreciate their response. And with that, I also want to welcome Ms. Karen Shippey, who I believe joined us since the start of this meeting. You're most welcome, Ms. And then I want to hand over then again to Ms. LaRosse, just to take us briefly through the pieces of legislation that will be repealed through this bill. Thank you. Over to you, Ms. LaRosse.
Thank you, Chair. I'm just going to quickly call up the relevant document so that we can talk to the bill itself. Apologies, I'm just having a bit of a problem with the sharing for some reason. Okie dokie, there we go. Honourable Chair, then just to note, this section of the bill which deals with repeals, a schedule of repeal of laws, and just to go through the individual sections as requested, or the individual pieces of legislation. So the first on the list here is the Seashore Act 1935. You may all note that this is extremely old order legislation, pre-democracy, not aligned to the constitutional mandates of different spheres of governments, certainly not aligned to the legislation, the modernized legislation. And indeed, sections of the Seashore Act are also proposed to be dealt with under new order legislation. And here I need to specifically refer to the National Environmental Management Integrated Coastal Management Act, which provides for the management of the seashore and areas just below the high water mark, which is now currently dealt with under the Seashore Act. Further activities that and access to such areas are also being dealt with in parallel legislation under the national environmental laws. So the whole of the Seashore Act is intended to be repealed in terms of providing for modernization, constitutional alignment specifically. I'll move on then to the Mountain Catchment Areas Act, and just to note that large sections were actually assigned to the province And indeed, what we have provided for specifically in the legislation is the continuation of those specific areas. In other words, they will still live into the future, but noting that this is a placeholder for the ability for these mountain catchment areas to either be protected under the proposed mechanisms for strategic water source areas, as is being undertaken by national government currently, both under potentially the National Water Act and under other national legislation in the NEMA family. But to note, we've provided for these areas not to lose their current protection measures insofar as they are protected. However, we have noted in the detailed comments that we see the regularization, the slow transition of these areas into formalized protection, protected area status, such as protected environments, nature reserves, or other effective conservation measures which are being developed currently at the national level. Then to move on to the family of nature conservation ordinance legislation, the 1974 legislation, the 1982 legislation, and 1999 as well, which relates to the nature conservation ordinance. Note that this again is specifically provided for in terms of the sections of the bill. And as we've designed this bill to be framework legislation, it must be noted that details, for example, in terms of processes, requirements in terms of applications, etc., listings, are to be dealt with in subordinate legislation under the bill. But indeed, we've taken great care to make sure that we do not have major omissions in the repeal of the Nature Conservation Ordinance and its regulations. Then perhaps just to look then at the Western Cape Nature Conservation Board Act. The bill provides completely for the governance arrangements and the roles and functions of various parties, and has done so comprehensively, I believe, in terms of being able to replace the content of the Cape Nature Conservation Board Act. Indeed, it's identified areas of modernization for Cape Nature, specifically in terms of its roles and functions, and clarified the relationship between the various parties that are identified in the Act itself. And then I would say similarly for the Act 3 of 2000. Then maybe just last by mention would be the Western Cape Biosphere Reserves Act of 2011. Even though it's relatively modern, this is quite detailed legislation, and it was seen as desirable to incorporate this legislation and also to rationalize the amount of detail in the 2011 Act, and to look rather at removing some of the detail, providing for what is absolutely required in framework legislation, and enabling anything that is further required to be in subordinate legislation, such as regulations. Honourable Chair, we'll stop there and hope that that has met the requirements that you had in your request. Thank you.
Good. Thank you very much. Thank you for that. Honourable members, it's now over to you for any questions, input. Thank you for listening so attentively. And if you could just indicate by show of hands any input, any questions regarding the long list of public input and the comments on that public input that you may have. Good. In the absence of any hands, may I just ask, and we're perhaps going to jump around a bit, I think I understand the need of the City of Cape Town, whereby they wanted the rights of conservation officers to be also extended to the rangers. Now, you have said that your problem in doing that is the fact that they have got a different employer and that, they are not in the employment of province. Is there any way in which one would be able to circumvent that problem? Or would it be required then for municipal ordinances to be able to give people the right to be able to also have the same abilities to examine, etc., as what the officers would have? And then secondly, I see that the officers would be designated as such, and for me the bill is somewhat vague in saying that the people designated as such should have the necessary qualifications, but there is no requirement. The qualifications are not clearly explained in the bill, and I'm just wondering whether some form of training should not be required in terms of the legislation, and particularly in terms of the rights of members of the public and others to be examined and for their vehicles and other containers to be examined. Just first those two from me, and then Honourable Maran, if you would like to add at this point in time.
Not necessarily. Thanks very much, Chair, and good afternoon to everyone. Not necessarily, Chair. I think what we should do is to first say, to take note of all the comments that's been made. I think some of a great number of those comments, some of the issues has been already captured within the bill. Even if I understand correct, Chair, that and at your right part of that particular presentation, all the comments that's been forwarded, there was also recommendations for this committee to say certain portions or certain parts to be included within the bill, to give consideration to those. And if there's any other, we should also do that, Chair. So that's basically mine. It's to want to say, note the comments that's been made by different departments, by the public and different individuals, to take note of that part, but also to give considerations to the parts where they specifically say we should consider to add that, but within the biodiversity bill. Thanks.
Good. Thank you, Honourable Maran. And I presume you will lower your hand now. Can I just ask for a response? Is it going to be Ms. LaRosse again?
Thank you, Chair. I will just start off the response in terms of the ranges and the requirements, or let's say the designation, the full designation that only applies to nature conservation officers, which are within the employ of Cape Nature. Just to note, within the bill itself, the Chief Executive Officer must designate suitably qualified persons. So while the bill does not specify what such qualifications would be, they would change from time to time, and her considerations or his considerations then in terms of such designation need to seriously assess whether that designation is appropriate, because as you correctly point out, enforcement officials take a great responsibility in terms of dealing with our rights as citizens. And hence those individuals need to be properly trained in the implementation of legislation. So there are other mechanisms for local authority officials, certainly under their own bylaws, can provide for such abilities and capabilities, but also to note that it is the intention within this bill to actually ask and speak to the actual designation of nature conservation officers and rangers as peace officers as well. And that is specifically in terms of the powers and functions performed in relation to the CPA. So there are other remedies to address that particular concern. However, for the CEO to take responsibility for let's say, cadre of enforcement officials not within his or her direct control is a risk that we've decided not to embrace in the legislation. And then maybe just in finality, there is also ability, and this is what's currently happening, is certain municipal officials can also be designated as EMIs, and certain individuals within certain local authorities have already indeed been designated as environmental management inspectors. I wonder whether my colleague Dion would like to weigh in, Dion Hignett or Ms. Burse, just to check whether they would like to add to that response.
Please.
Nothing from my side, Chair and Marlene. You've pretty much captured it 100%.
Thank you, Marlene. Thank you, Chair. I do think that Marlene has captured it fully in terms of, what Cape Nature is accountable for, and then obviously the responsibility and accountability rests with the CEO as far as it concerns the appointment of non-Cape Nature employees as nature conservation officers, who would then need to be able to apply the full scope of legislation relevant to this bill as it relates to biodiversity, whether it is issuing authorizations or checking compliance with authorizations. And because all of those activities fall out the scope of municipal employees, it is not desirable to have them appointed with the same powers as nature conservation officers in terms of this bill. Thank you.
Good. Thank you very much. Honourable members, please, I wouldn't like to, be the only one asking questions, but and therefore please feel free to raise your hands. I will give you an opportunity as I recognize you. Can I just, Ms. Laros, I've got a particular interest in governance and the functioning of governance structures. And interestingly enough, the input that we've received have been quite quiet on the clauses dealing with Cape Nature and the function in particular of the board of Cape Nature. Now, it's been my privilege to previously serve in the National Assembly, and there we've had a case, I think it was with the Public Service Commission, where both the chair position and that of deputy chair was vacant for a considerable period. And whereas one never wants to anticipate such a situation, it is unfortunately the fact that some political parties, the ministers can't take decisions on their own. They wait for instruction from a so-called deployment body that, also forwards names of people, etc. And I'm concerned that if we look at clause 16, chairperson of board, that under 3B, we may have a problem if the provincial minister may appoint any board member as acting chairperson of the board if the chairperson and vice chairperson are absent from 2 or more consecutive meetings of the board. Now, first, under chairperson of board, I'm just asking, because it seems to me as if the vice chairperson's position at one stage is somewhat limited, and I'm just wondering whether there should be a clause 4 to say that the vice chairperson will act as chairperson in the absence of a chairperson, or when requested by the chairperson to do so, or if the chairperson is unable to fulfill his or her duties. We sometimes have the case where people may have an illness or capacity for a limited time, or where people want to go on leave and where they wouldn't be able to perhaps attend a specific meeting. Now, absenteeism in general, it seems to me, is a factor because if the chairperson doesn't, in terms of this bill, allow people to take leave, it seems to me as if the right to grant people leave of absence is limited to the chairperson. But now we have a problem in that, the chairperson cannot grant him or herself leave of absence, I would presume. And therefore, if the chairperson is absent for 2 or more consecutive meetings of the board, and the board may have to meet, for a special meeting at quite short notice, that the chairperson will then be forced to vacate that position as well. So I've got certain questions in that regard, and you've heard my proposal, whereby perhaps this can be covered. Then also, in the case of the Public Service Commission, as I've said, they were actually unable to function in the absence, because only the chairperson, in terms of what I read here, can call for a meeting of the board, and it's the chairperson that must call for a meeting if a majority of members request him or her to call for such a meeting. So again, if the chairperson should resign and there's a vacancy for a vice chairperson, who can now call for a meeting? Who can, in the local government sphere, we know that the municipal manager will, for example, call the first meeting of a council, and there, some of the office bearers will be elected. In this case, the office bearers will be appointed by the minister. But as I've said, we have seen cases where the minister has been unable to do so within a reasonable period of time. So I've also wondered whether we shouldn't include a clause where the CEO may call for a board meeting to, unless, or in the case where there's no chairperson or deputy chairperson. I see my notes also read here, should the chairperson, vice chair, or acting chairperson is unable to, if there's no chair, vice chair, or acting chairperson for a period of 4 weeks, the CEO may call a board meeting. So that's just a consideration, because, as I've said, I have seen where unfortunately a board was unable to function due to the extended absence, and the chairperson is not only the person that calls for meetings, but I presume the chairperson would also be, in terms of delegated powers, be the one that the CEO must consult if he or she wants to go on leave, etc. So perhaps if you could just help us on the situation of the board in such cases, and whether there wouldn't be perhaps a way to get out of this potential predicament. Then also under the duties of Cape Nature, I find it interesting that while they've got the power to raise funds, that there's no duty on Cape Nature to also see if they can find funding, be it locally or internationally, or even raise funds through its activities. It's a power of Cape Nature to also then contribute to conservation and ecotourism opportunities, but it seems to me as if the raising of funds has been omitted. Is there a specific reason for the way in which those clauses have been put? Thank you, Mr. Laros.
Thank you, Chair. I hope not to miss anything, but I have noted down the comments and questions and we'll work through them systematically. In terms of providing for Vice Chair to be able to function, I think we need to consider that carefully in relation to this whole section of the bill. Specifically, I think what is intended is that in the absence of the Chair, the Vice Chair chairs such meetings and provides for such functions. In the context of that relevant section, though, want to point out within that same section that the intention is that the chair, the position of chair is not left vacant, and that the board remains functional. So if there's any impediment in how that is currently crafted, we should really review that. But also to note that Cape Nature, and this is the way in which many boards operate these days, has a board charter which speaks to specifically the rules of the board itself, its own performance management and monitoring is taken up in that, but also how its committees function. And that is quite detailed and quite rigorous from what I've seen thus far. So I think we just need to take time to look at your concern in terms of the Vice Chair and the Chair not being available, and the concerns that there may be a gap in that particular portfolio for any period of time. I think we just need some time to reflect on that, Chair, if possible. And then in relation to calling for a meeting, I think it relates to your earlier concern. If for some reason members are errant, I think we've been fortunate that we haven't experienced this at all in the functioning of the board. I think the board has a high level of functioning from a governance perspective. We've also had the benefit of engaging in the recent guideline development for public entities, which is being driven by Provincial Treasury currently, and specifically addressing these sorts of governance concerns. And we've also seen that there's strong alignment there in terms of the provisions that we've provided for here. In relation to the CEO being able to call a board meeting, I think we need to specifically look at whether that is from the committee's perspective seen as desirable. I think the CEO, the CEO's office in any case provides for the regular quarterly cycle of meetings. Ultimately, all the affairs of the board are dealt with by the board secretary and involved with and led by, that is led through the CEO's office. So, but it's something which we should take on and consider carefully based on your input, Chair. And then finally, in terms of the duties of Cape Nature to raise funds and to find funds through its activities, I just want to refer specifically to 11.1, which enables Cape Nature to, subject to the Public Finance Management Act, which I think is a really important qualification, to generate income by any lawful means. And this includes entrance fees, authorizations, concessions and leases, nature-based ecotourism facilities, events and services, activities in the biodiversity economy, maintenance of ecosystem services, that's actually doing, for example, keeping catchments clear for municipal water supply as an example, fees resulting from intellectual property rights, in other words, primary research and other, and conservation and other services. So we think we've been as, let's say, all-encompassing as possible in relation to the nature of the business that Cape Nature would be able to generate income through. And I'm just wanting to know whether you've considered 11.1 A to F in that particular context. Thank you, Chair.
Yes, thank you, Mr. Ross. I have seen that, but I've noted that is under the powers of Cape Nature. It's not under the duties of Cape Nature. And I was just wondering whether one shouldn't, also expect of Cape Nature, not only give them the right to do some things, but also expect of them under their duties to also contribute to ecotourism and to raise funds, perhaps even for research and for the other activities as listed under the powers that you have there. Then can I just quickly refer you, unfortunately, it's only under meetings, the operating procedures of the board, 23.3, if both the chairperson and vice chairperson are absent from the meeting, the members present must elect another member to preside at the meeting, subject to section 16.3. So the rights of members to kind of get out of the conundrum where they have what you call delinquent chairs and vice chairs. They can only have somebody that preside at the meeting. That person would not be able to, for example, write to the minister to point out to the minister that the members have got a problem, or that, for example, to determine the next meeting's date, because it's only the chairperson may convene a special meeting, or the board must meet at least 4 times during the financial year, and the chairperson may, and at the request of the majority of the board members, must convene a special meeting. I'm referring still to Article 23(1). And again, it seems then that the chairperson must convene and preside at meetings of the board, but if the chairperson is absent from a meeting, the vice chairperson must preside. I can just imagine that there may be other cases as well where the chairperson would not be absent, but as the chairperson may feel compromised, or as the chairperson may feel unwell, that the chairperson would be able to request the vice chairperson to preside. So I just think this may be a little bit limiting. And as you've said, if everything goes well, then these regulations are fine. But the problem is when things don't go well, then obviously there must be a way to circumvent some of the unfortunate circumstances that we have seen in other boards. I recognize Ms. Shippey's hand, and again, most welcome, Ms. Shippey.
Thank you very much, and I do apologize for joining you late. I was presenting to the National Department when you started this meeting, but I should have been here, so I apologize. Yes, Mr. Chair, I think your point about whether or not Cape Nature, as well as other entities as well, need to actively perform fundraising duties, I think we must be very careful about the precedent that we set by setting it into law, that they are required to, because essentially what we're saying is that government is not taking responsibility for the costs of conservation, despite it being a constitutional obligation of ours and a mandate both for provincial government as well as national government. So, I think it's obviously something which in the objectives of the organization of any entity should be to reduce its costs and fundraise where and how appropriate. But I would be very concerned about the legal precedent of obliging them in law to do so. And I'd like to hear from the legal advisors if there are any issues from their side, but I don't think it's required of other entities. And I would be very concerned if we're only putting that requirement on conservation. Thank you.
Good, thank you very much. Again, in the absence of any hands, can I just quickly also ask you and draw your attention to one of the interesting definitions. There's a definition for well-being, and the word well-being, I think, is only referred to 3 times in the legislation apart from the definition. And in the other two of the other cases, well-being is referring to human well-being. So in this case, well-being is being defined as means. Okay, and this has been changed now. The current one, let's on in front of us means a state where the living conditions of a faunal biological resource are conducive to its health. And then the alternate that's been proposed is well-being as it relates to animals, means the state of ecological, behavioral, physical, and physiological health of an animal. And I'm just, again, I think it's probably for our legal advisors to say, shouldn't one perhaps say well-being unless the context indicates otherwise, means the state of ecological, behavioral, physical, and physiological health of an animal. It is just, you know, well-being is not limited, obviously, to animals. For example, you will see under objectives 2D, there the term is used, ensure human well-being. And I just think that perhaps a rewording of saying when we define well-being, it's that definition only applies unless the context indicates otherwise. Okay. So that is just one question there. Then in terms of chapter 2, duties and principles, I think there under 5, there's an addition C. Then I'm just referring, I think there are a number of changes which you've actually proposed to bring about. And I'm just thinking that we should make sure that we should ensure that we are all on the same page when it comes to, for example, the B version of this bill. I have referred to my questions regarding the possible stalemate on the council, and you actually said that you would perhaps just go back and look at that one. Then I think the next one that I would like to highlight is under 40, and then in brackets 5. That one, notify the landowners concerned of the intended notice and the consequences of the notice and afford them a reasonable opportunity to comment. I think that is something which you have already alluded to and saying, yes, you believe that would be an improvement on the legislation. Then it seems to me 47.5 in brackets 5, that paragraph 5 be scrapped. I hope we're all on the same page there. And then under 52.3, that a new C be inserted there. Now you've got in your notes a Biodiversity Act. I was just wondering whether we are referring to a specific Biodiversity Act, the Biodiversity Act, because I see you've got it there with a capital B for biodiversity, which seems to me as if you want to refer to a specific one. And then on 52, before granting an application, I think it's an improvement that you have considered to before making a decision on an application for authorization. I hope we're all on the same page there. And then I'm not so sure if I'm completely satisfied with 56A and the Roman 1. The Chief Executive Officer may designate a suitably qualified person. Perhaps if you could just allay my fear that, you know, suitably qualified person should perhaps also be defined so that we don't have a rogue CEO that can appoint any person as a nature conservation officer with all the rights that goes along with the position of a nature conservation officer. Then 63, I think there you've mentioned that you're happy to replace the word search with examine. And then also, I could just understand my own notes. Oh yes, I've asked why not rangers too. I think you have responded to that one. And they under administrative penalties 71, a practice which seems to have been used to great effect in many other violations is what is generally known as spot fines. Now, in the case of administrative penalties, what this bill provides for seems to me these kind of administrative penalties whereby the administration would penalize somebody for transgressing environmental legislation. And here we're talking about quite often hundreds of thousands of rands and even more. But if you could perhaps just tell me, are you quiet on, let's call it smaller fines for there and then, transgressions, whereby people actually, acknowledge that they have erred and they pay a spot fine, and it's not necessarily or necessary to go to a court of law or to go the long route of an administrative fine. Perhaps if I could first just stop there and give you an opportunity to respond. Thank you.
Thank you, Chair, and please do remind me if I missed anything. I will be calling on my colleagues in Cape Nature also to respond. I think I'll start with where you've spoken to well-being, and I think that qualification to the definition could well be considered, as you correctly point out. It is used in relation to animals, specifically in the context of Clause 6, and I think that further qualification will specify its meaning. We should consider that carefully moving forward. In relation to the other changes, sir, that you've put forward, I don't think there was any dissent. The specific question that you've raised here on spot fines or admission of guilt fines, as they're also known, we haven't specifically provided for that in terms of the bill itself, but I'm going to hand to Coral or to Dion to just speak to the matter of admission of guilt fines.
I'll come in, yes, and if Coral's going to come in as well. A spot fine is just basically a J534 or admission of guilt fine, so the system does already exist. That's onto the first question. The administrative fines or penalties are a different thing altogether, and I don't think you should conflate the two, whether one is for a minor transgression which can be paid relatively easily, and an administrative fine or penalty is not exactly the same thing. So I think the system does already exist either in our bill or in the Criminal Procedure Act, if the question is about spot fines or J534 or admission of guilt fines.
Thank you, Dion. And then just maybe returning back to the issue that was raised, I think for a second time, Chair, in relation to the powers to appoint conservation officers or rangers, and specifically the interest to make sure that we qualify what does suitably qualified person mean in relation to this. And my question here is specifically in terms of the designation of these individuals, the competency of such individuals and their training is obviously what makes them suitably qualified. But perhaps we need to think about this in the context of any regulations that might be made in terms of the designation of nature conservation officers. But broadly speaking, suitably qualified persons would refer to the training that has been undertaken and their competency as assessed. Those are, and then obviously there's the added element of experience which goes into that, but those would necessarily be included in anyone's definition of a suitably qualified person, specifically for this role. Chairperson, I think that those were other than the matters that you've moved through, I think those were the two issues. There's one further one, and that relates to the Biodiversity Act. Indeed, if you look in the definition, Biodiversity Act in this bill is actually NEMBA as it currently stands, and that's within the definition. So that particular clause would refer to the Biodiversity Act, and as defined in our bill is NEMBA.
And the insertion of the word "the Biodiversity Act" would therefore not be out of place under C for 51(3)(c.
Exactly. It would refer specifically to NEMBA and responds directly to the comment made by our national colleagues in addressing that comment.
Good, thank you very much. And then obviously C will be renumbered D, just following on that one. Good. Thank you very much. Thank you, Ms. Laros. Honourable members, are there any of the other changes that anyone would like to comment on at this point in time? Because I think then at one stage the next phase for you, Ms. Laros, would then be to prepare a B version of this bill, I presume.
Sir, we would take your guidance here in terms of the committee's procedures, but certainly to consider and to prepare with the assistance of your parliamentary legal advisor, Advocate Marsdorf, the comments and the responses to this and the proposed changes, but also further, sir, to take on board and consider the issues that you yourself have raised this morning or this afternoon, and specifically in terms of the residual issues as I see them relating to some of the governance mechanisms in the relevant sections dealing with the chairpersonship and making sure that we don't have a problem in terms of errant situation of a board. And I think that we need to consider carefully, and then also in relation to trying to address the issue of suitably qualified people being appointed by the CEO as nature conservation officers. I see those as two sort of residual issues we need to think about in terms of how can we machine the wording or provide for such definition that clarifies and addresses those concerns.
Thank you. Thank you for being willing to take on those and to come back to us. And if I may ask that you perhaps, I think Mr. Hignett obviously, had to respond now, but the admission of guilt fines, I'm just wondering whether it wouldn't strengthen this. If you would just go back and have a look, if you say no, it's already suitably covered. I just think to make provision for that would fit in quite nicely. Also under appeals, where any interested or affected person may appeal to the CEO against the decision taken by a nature conservation officer. Also, so that, such fines be reviewed on a regular basis. It seems to me that these, quite often when people set their budgets, and in some pieces of legislation, it says that these fines can only be reviewed once a year. And unfortunately, that once a year is often where budgets, etc., are drawn up, and then people omit to attend to this. And then we find that some of these admission of guilt fines, are lagging behind. Good. So if I can just leave you with that as well for something to go and consider, and then come back to us, I'll really appreciate that. Can I just ask Advocate Marsdorp, any comments from your side at this point in time regarding what has been presented to us today and the questions and other issues raised?
Yes, thank you very much, Chairperson. I have raised one issue with my colleague Lionel van der Schijf, and he has indeed replied, and Ms. Laros is certainly aware of that reply as well.
Would I maybe just, for the record then, draw the committee's attention to that issue, and with the indulgence of Ms. LaRosse, if you could just share, Ms. LaRosse, through the chair, clause 63 then, you certainly, with my colleague Lionel van der Skerk, have responded in email to my email query. And I would like to maybe just draw the committee's attention to the issue I raised, the issue you have responded, and a further concern emanating from that. It's a small issue, but I think it may be necessary for the committee to have sight of it. Would I ask that you share that clause of the bill, 63(1)?
Yes.
Yes, thanks so much. Chair, this is an issue that was also raised. The chair will remember that at the previous meeting, I indicated that I needed to just raise something outside of the meeting with my colleague van der Skerk. And this is also an issue which was raised by the National Department pertaining to the competencies of the Nature Conservation Officer. Take note, without a warrant to effect a search and entry to premises, without a warrant. Now, whenever I read something along those lines, then of course one becomes immediately sensitized, because you want to guard against intrusion of private spaces, be it homes, be it any premises, any container, any box, any bag. You want to have a balance. We do know, and especially as lawmakers, we do know the responsibility, the profound responsibility on lawmakers to inculcate, to instill in our legislative regime a human rights culture, an ethos of sensitivity for private space, and to very strictly, to very discreetly manage any state sponsored intrusion. Now, a nature conservation officer would represent a form of official authority, and for him or her to, without a warrant, just enter premises, enter private space, that is something that one should be alerted to. Now, my colleague in his response has indicated, and I see in her presentation earlier, Ms. LaRosse has indicated that one can then replace the word search with
examine.
Examine. Now, if that is what we accept, then the section or clause 63(1) would then read, and I read this for the record and completeness, a nature conservation officer subject to 58 may at any reasonable time conduct a routine inspection and without a warrant enter and inspect any premises or examine any bag, box or other item for purpose of compliance. Take note, I am very mindful of the distinction between between inspection and investigation. Now, with respect, the word examine is simply just a circumscription of the word search. I cannot see an examination that would not include the activity or the exercise of search, or vice versa. Take note, without a warrant and for purpose of an inspection. However, having said all of that, I would like to maybe test my colleague's response with the following suggestion. If the objective at that stage of a conservation officer is to inspect merely for compliance, then I would suggest that the word search is an overindulgence, without a warrant that is, in this section. I would suggest, Chair, that the sentence instead, or the provision instead reads, without that word search or the word examine, and it would still serve the purpose that is sought to be attained with that section for purposes of inspection. In other words, I would completely remove the word search, remove the word examine, because the emphasis then would then fall on two words, namely enter and inspect. So I read, a nature conservation officer may at any reasonable time conduct a routine inspection and without a warrant enter and inspect any premises or bag, box or other item for the purposes of compliance. Take note, my concern is only insofar as it relates to doing all that activities without a warrant. Later on, 64, etc., where there's purposes to be served for with the intention to investigate, that's a completely different story, which has a different regime, if you like, that manages it. But where an officer simply encounters or seeks to monitor for compliance, can just intrude on private space, willy-nilly, goedsmoeds, without a warrant, while there may be sufficient opportunity to obtain a warrant. That for me is a red flag, and it flies in the face of our attempts to, through legislation, instill or inculcate an ethos of human rights sensitivity and respect for private space. So I would like to test my colleagues' response on the complete elimination from that provision in 63.1 of the word search or the word examine, and to simply stick to the objective of seeking to inspect, enter to inspect for purposes of compliance. That for now, Chairperson. Thank you.
Thank you, Advocate Marsdorp, and thank you for very much for really highlighting a potentially worrying issue, or something which could be abused as well. And it seems to me also as if in this bill there is no actions or remedies where such rights may have been abused by officers. And I'm just with you on how can this be balanced, and how can we ensure that if this section is abused, that there will be some reprieve for those that may suffer under abuse of this. Can we get your comments? Is it again Ms. LaRosse or Mr. Hignett?
Thank you, sir, and thanks to Advocate Marsdorp. I think he's possibly provided the solution in the wording. It would be good to perhaps capture that in writing, perhaps in response to Lionel's email. But ultimately, the intention is an inspection, and the wording thus, if it has raised concerns in relation to infringing of rights in a routine inspection, which is now always only conducted where you should expect the person who has potentially in the possession of specimens or whatever for which they require a permit or an authorization for you to be able to check that in situ. And the intention really is that, you know, sometimes you're dealing with small specimens. You may be presented with a set of boxes on a counter, for example. You need to open up those boxes and look inside those boxes. And I don't think that the change of the word from, or say the removal of the word search or examine and the use of the term inspect, I think, is helpful because it then consolidates the intention of that action. So yeah, with thanks, I would like to just hand over to my colleague Lionel van der Schyff, that he can also provide his opinion on the matter. Thank you, Lionel.
Thank you. Thank you very much. I just want to add something, that this provision here is never intended for the search of private spaces, the inner sanctum of privacy, such as your home. That's not the intention of this search. This search, a warrantless compliance search, is for a routine inspection of juristic persons that are commercial enterprises and that are licensed. These entities have a lower expectation of privacy than, for example, an individual in their private home. So Advocate Marsdorp repeatedly referred to private, inspecting private matters. That's not the intention. And if necessary, we need to clarify that, that these searches are to be undertaken in licensed commercial premises, not private homes. Thank you.
Thank you, but I don't see any qualification there. It just says any premises. And I'm also not sure if this really provides, for example, also for vehicles, or would a vehicle then be included under any item? We all know that, you know, where illegal transactions take place, normally goods are transported. And what we do see is from time to time routine roadblocks, etc. Would this also be included or under this? Because I can imagine that there's a need, but I also can imagine that we should have something which, if I have something against, a grudge against somebody, that I'm a nature conservation officer, that I don't abuse my position by going knocking on that person's door 10 times a night and say, please open up, I want to inspect. So it seems to me as if at this point in time, it's a really quite widely described right that those officers have. Thank you. Again, over to you, Ms. Bursch.
Thank you, Honourable Chair. I think I just wanted to make the note that in terms of it being an inspection that relates to where an authorization has been issued. So a routine inspection is not in the sense of investigating where a crime has been committed, where it's, you know, would relate to a search warrant, but where an authorization, whether it be a license or permit, has been issued to do an inspection to ascertain compliance with the provisions of whichever authorization has been granted. So it isn't just pitching up anywhere and searching anything.
Sorry, you will have to just
speak closer to my microphone.
Apologies.
No, it's fine. I was saying that the intention is in relation to where an authorization may have been granted, whether it is a license or a permit or an authorization, which is not just limited to commercial enterprises, but where an authorization has been issued, and a routine inspection would be to see compliance in accordance with the specification of the authorization. So it is not a a la carte access to any property for any reason.
Okay, as you've just rightly pointed out, and that is where I got the notion from, that this also includes, for example, routine vehicle inspections at what I would call a roadblock. where is this, let's call it a routine inspection at the roadblock? Surely this is included under this, and not only for people with licenses, or where somebody has been granted the license, and you now want to see if that person is conducting his or her business in agreement with the license.
I think Marlene wants to respond to this, Honourable Chair.
Please.
Thanks, Chair. I think it's really important to note that basically conservation officers on their own, NCOs, and even EMIs do not have the power to institute roadblocks on their own. And those are generally parts of broader operations that do take place. I'd also like us to just be aware of the definition of premises, that indeed, I'll just quickly put that up, that it does cover the following, it does include the following. It means any land, site, property, building, structure, or any part of any land, site, property, building, or structure, and includes any container and any vehicle, train, railway, carriage, vessel, aircraft, or any other conveyance. So the reason why you can see the words box, container, bag, etc., is because they don't contain, those are not premises. Those are things that you may have specimens inside. But nonetheless, the routine inspections may only be applied to a context where the regulated community has an authorization for which one should be able to ascertain compliance therewith. And I really would move that the suggestion on the wording provided by the advisor, Advocate Marstorp, is a very elegant way of solving the conundrum or solving the problem, and ensuring that there is no straying into the space of warrantless searches, which I think is a very important principle. So I just want to thank Advocate Marstorp for providing, I think, a potential solution in this regard. And I wish I'd been able to write fast enough just to capture the wording as was articulated by him earlier. Thank you. Thank you, Chair.
Thank you, Mr. Ross. I would prefer it if you would word it as follows and say, and without a warrant, and we'll come back to this clause again, and without a warrant, enter and inspect any premises or inspect any bag, box, or other item. Obviously, one can't enter any box or bag for the purpose of ascertaining compliance with. I fully understand the need. If I've got a permit to hold, let's say, 50 crocodiles, that an officer from time to time should be allowed to come and see whether I have only 50 crocodiles, and whether I am still complying with, say, for example, the fencing requirements as set out when I was granted a license or approval to keep crocodiles on my piece of land. That I can fully understand. But again, I don't see where it's prohibited or where there will be any consequences for any officer if he or she abuses the right granted under this paragraph 63. And in that respect, I am concerned that it is open for abuse. And this is obviously something that we should guard against, in my mind. Perhaps if I can get an indication of who would like to respond, is this perhaps something that we should refer back to you, and which you and Advocate Marstorp would like to take first offline, and then present us with an alternate wording?
Thank you, Chair. I think that would be most appropriate if we can consider those the potential issue that you've raised around consequences, remedies for any abuse of power in relation to nature conservation officers or rangers or other enforcement officials. I think we need to have a view to what exists already and see if it's necessary to include something specifically in the bill.
Good, thank you very much. And I would appreciate it if at a further opportunity you would be able to respond to some of the issues raised here today. Honourable members, I think I speak on behalf of the committee if I at this stage then say thank you very much for the incredible work that you've done. Thank you very much also to Advocate Marstorp for going with us through this and attending our meeting and raising also a very pertinent issue. And that then obviously brings us to the next step in this process. My understanding is that we will, at a further meeting, be receiving feedback on the issues raised. And obviously, you are welcome to discuss between Advocate Marstorp and yourselves, even between individual members of this committee and yourselves. If you believe that some of us may have missed something or that our comments may be out of place, please feel free to engage with us. Now, honourable members, we are going on to a constituency period, and I think it's, I speak on behalf of us all again, if I say that obviously we wouldn't like to delay this proposed bill or this bill any longer than what is needed. So we've got a number of options if we want to, for example, finalize this issue before the December recess, which personally I would very much like to see. And one of those would be for us to either meet during the recess, which I think wouldn't be a good option, as recesses should be, I think, respected for that. But then it might require that after the elections and after this recess, we may have to schedule, I almost want to say, extraordinary meeting slots. Perhaps on a Monday, if we really don't find any other open slots, perhaps even in an evening. And I have already heard that the officials, having worked so hard and long on this, would also like to see the end of this process if possible, and that hopefully you would be willing also to join us after hours if it can help us to really progress on this bill. Unfortunately, once we return from the recess, there's only about 4 weeks of meetings left, and the fourth quarter is quite full. All the slots available have already been booked for a fast-tracked program during the last 3 weeks of November and the first week of December. So, honourable members, you're welcome to comment on this possibility that I'm raising, that we schedule extraordinary meeting times to deal with this and to try and present this to the legislature at its last meetings early in December for finalisation by the Western Cape Provincial Parliament. Any comment on that? Anybody that has got a different view? Please, you're welcome to respond if you so wish.
No, Chairperson, we agree with you.
Good, thank you very much. I presume that also represents the view of other members of this committee. Ms. Shippey, I see you've switched on your camera.
Yes, thank you, Mr. Chair. Just from the department and Cape Nature side, as you said, the officials have been working an extremely long road on this particular bill, and we will make ourselves available when the committee would like to see us. Thank you.
Thank you. That's a wonderful commitment. Thank you very much. And I will ask Ms. Nikak then also to record it as such and also to help us in finding suitable extraordinary time slots when we return. There will obviously then be, as I envisage, first a meeting to get clarity on some of the issues raised, and then we will be going clause by clause through the document and then eventually present the whole document to the committee, which will then be sent through, should it be approved, to the Provincial Parliament. Thank you very much. And with that, I'm going to close this item on our agenda today, which will leave us now with the remainder of the agenda, which is then the consideration and adoption of the draft minutes of 24 and 31st of August. And with that, Ms. Shippey, to you and the officials, I want to say thank you very much. You're obviously, as is customary, free to leave or to remain on, as we will now be moving to administrative issues of this committee. Thank you very much again.
Thank you, Mr. Chair.
Thank you, Chair.
Thank you. And a special thank you to Ms. LaRosse.
Thank you, Chair. Thanks, honourable members. Strength to your arm. Thank you.
Thank you. Thank you. I believe that Ms. Nikak is ready to present us with first on screen with the minutes of the 24th of August, 2021. Thank you, Ms. Nikak. There it is. Honourable members, it has been circulated to you, and I would appreciate it if you could just quickly confirm whether you are in agreement with page 1. And then page 2. Can I have a proposal that we adopt the minutes? Thank you, Honourable Maseko. I recognise you.
Thank you very much, Chair. Chair, I do propose that we adopt the minutes.
Thank you. Any others? That Honourable Maran, I see you're unmuted.
Second, Chair.
Thank you so much. It's then adopted. Thank you, Ms. Niekerk. The 31st of August. Thank you. I see Honourable Maseko apologized for that meeting, so she wouldn't be able to support this. Honourable Maran was also not at that meeting. So it seems to me perhaps between myself and Honourable Bartman. Honourable Bartman, I recognise your hand.
Thank you, Chair. I move to adopt.
Good, thank you. And I will support that. So thank you very much. That is then also dealt with. Thank you. Then, honourable members, we've been delaying the consideration of the report on our oversight visit to Elsenburg on the 8th of June 2021. Again, it was Honourable Bartman, Maseko and myself. So that report has also been circulated, also previously. Ms. Nikak, if you could just quickly scroll through that report. Honourable members, you will recall that was also when we discussed or we had a demonstration on the unmanned aerial vehicles, or drones as they are often called, and where we were also visiting the agri-processing hub, where the department is assisting young entrepreneurs, small, medium and micro enterprises, to establish their businesses in the agri-processing environment. Can I get a proposal? Honourable Maseko, your hand, and then Honourable Bartman.
Yes, Chair, I move that we adopt.
And then Honourable Bartman.
Seconded.
Good, thank you very much. Honourable members, are there any other issues that you would like to raise before we adjourn this meeting? I don't see any hands, and then I want to say thank you again, all members, for joining us all the support staff for making this possible. And I wish you well also over the recess period. Be safe. And I'm looking forward to welcoming you again at our next meeting. Thank you very much, and have a good evening. Thank you.
You too.